May I please, Lordship? These are the stone quarries in Kaziranga. I think your Lordship has also had occasion to deal with it. We are on a very brief and small point, Milord, at the moment for today. Milord, we applied before the state government for the district council for operating our stone quarry. The DFO wrote to the director of mines there, this is outside 10 kilometers. Kindly prepare your mining plan for this. That was done. We got the required clearances, environmental and all that, whatever it is. And thereafter, we will operate it. We extracted, we paid in advance, you have to pay. So it is 90 lakhs is the total sum for 2 years, so that we can extract stone to the extent of 90 lakhs. We have already paid almost 60% of that amount, 54 lakhs. And we have started the extraction and the stones were lying. At that point, my lord, they have suspended all the stone quarries there without notice, which is again violation of their own rules. But keep it aside. We were allowed to operate. We operated. Our extracted stones are lying there. We get the suspension order. We can't now remove. Let us not get involved in the main issue, but this is the substance of the matter so far as today's proceeding is concerned. In some cases, this court has said that let them remove the extracted stones because they have accepted our money earlier. We have been authorized to extract that. We have extracted. It is lying there. We should be allowed to remove. That's this simple play. And we have annexed 2 orders of this Honorable Court. If your Lordships kindly have a look. 1041, the other one, 118, I think. One is at page 104, my lord. Similar matter, operative part is at 109. Same kind of situation. Huh? No, sorry. No. Page 109, Miller, para 8, hard on the interim prayer, having considered that the petitioner has been allowed to operate the stone quarry at the designated area of Norpam PP area after all the mandatory statutory clearances and considering that the petitioner is already operating the stone quarry, as well as no notice to suspend or otherwise appears to have been issued to the petitioner, in the interim it is provided that the petitioner shall be permitted to remove the already extracted stones from the designated area of stone quarry at Norpani. This is the interim order given in a connected matter of a similar nature. There is no dispute about 2 facts. One, that mining was allowed to be done. It is a legitimate activity on our own land. Second, we have paid substantial 60% of the amount fixed for 2 years, namely 90 lakhs, and we have removed, extracted, and they are lying there. We could not take it out because you suspended it. Now, my lord, if you don't allow us to suspend or take it, then return the money. You can't have best of both the worlds. But I don't want the money, my lord. The extracted goods is lying.
Okay, let me read the order first.
Where is one? Oh, your lordship, please.
What is that 11/7/2025 communication?
11/7/20.
Which page?
There are two impugn orders, my lord, page 52 and 100.
52.
100 at
100.
page 6/11/25, my lord. That is, my lord, when the suspension order was passed, we moved this on the court.
Page 107,
Yes,
paragraph 2,
yes.
11/7/2025.
That is in that case, my lord. This is not in our case.
Okay, okay.
In a similar matter, I was trying to show that this interim relief was given, namely that you can take away your extracted goods because it is lying there. It is in the interim order is passed in that case. Similar case, Miller. In fact, Miller, earlier also, page 52, if your lordships turn over, this is the impugn order, Miller.
Whereby you were granted settlement?
Suspended.
Where is your relevant documents? Otherwise, the petitioners.
Oh, so far as our right to operate, Miller, yes. Just give me a second. Citycon compulsion. Directorly dear Citycon. Will you kindly turn over to page 29. The DFO is writing to the director, Geology and Mining, with reference to the subject above. I have the honor to inform you that the above mentioned PP Landstone query is settled with Sri Jiten Anglai for collection of 30,000 metric cube sandstone accordingly. White KSC letter dated so-and-so, dated 28/10/21, and special Chief Conservator of Forest Karbi Anglong letter number so-and-so, dated 16/11/21, issued LOI, letter of impact, to him at a reserve price of 90 lakhs, only along with 15% monopoly fees for a period of 2 years. Now, as per provision of Rule 49 of the Assam Concession Amendment Rules 2018, as mining plan is to be submitted by Jiten Anglai, and he has deposited 21 lakhs, only being 10% of the bid security, and 1 month advance contract money and 10% additional amount required for restoration and rehabilitation fund towards the District Mineral Foundation Trust. Therefore, I request you to kindly prepare mining plan in connection with lease permit area Naupani, so and so, which the related documents are enclosed herewith. This is for your kind info later. So the settlement order, sketch map and all that. And then, my lord, this is the divisional forest officer himself writing to the director that prepared the mining plan. And the mining plane has been done it. And at page 31, if your lordship sees, the amounts, the area, the period, all this is contained at page 31. This is the letter coming from the Divisional Forest Officer to the Director Mine.
Yes,
Asking-
respondents.
My lord, in the referred case, my lord, that confront Tehran, one judgment has been, of the Honorable Court has been quoted, my lord, that similar orders has should be
107.
107, my lord. In that case, my lord, we are filing one affidavit today. It's in the course of filing, one connected with it's 5200 of 25 and 5402, bringing all the pertinent instructions and records in the on record, my lord. What has happened, my lord? This issue, my lord, has emanated from T.N. Godavarman. T.N. Godavarman constituted CEC, my lord, Central Effort Committee, which looks after the compliance of the directions passed in the T.N. Godavarman's case, which is still going on in the Supreme Court. Every action of the authorities in suspending those mining operations had happened due to directions passed by the CEC. Now, the CEC is a permanent body. So, my lord, my lord, the affidavit spells out everything, my lord. CEC has been given by the Honorable Apex Court, my lord, a permanent form. It's a permanent body now, by this one judgment, my lord. So, my lord, the Supreme Court is in possession of the matter, my lord, these all issues, my lord. And this area, which it falls within the, my lord, the ESZ of the Kaziranga draft proposal is pending with the Ministry of Environment and Forest at union level, my lord. So, as of today, my lord, the ESZ is 10 kilometers, and the mining operations are non-forest activity which are prohibited under that, my lord, ESZ, my lord.
No, was there any challenge in this to the interim order or other interim orders?
No,
No challenge, my
no.
lord, because, my lord, we are in the because CEC has again.
My lord, regarding, my lord, interim order, my lord, CEC issued notice to us, my lord, whether we have pointed out to the Honorable Court, Supreme Court's order or not. CEC, my lord, again, my lord, we went there, that our officials along with us, my lord, we went there, my lord. CEC, my lord, again issued the order, my lord. It is, my lord, in respect of that particular order, CEC wrote to the Registrar of the High Court to place it before this Honorable Court. And the direction to the, my lord, Chief Secretary. Lord, we'll look into that one. We can bring it on record by way of affidavit also, my lord.
CEC is a party. Why are you bothered?
So I had only pointed out.
No, let me be clear about it. We have made CEC a party in this case. They have received notice. They are respondent number 15. If they have anything to say, they should have filed an affidavit. It's not for Karbi Anglong to say about that now. After what you have done yourself, allowing all this. No, your lordships have also noticed, CEC has received the notice, 18 to 26. That order clearly notes that CEC has also been served with the notice along with the petition. Milord, if I may just point out, Milord, this is some kind of a cloud which is being sought to be brought. But the facts are, as your lordship has seen, the DFO writes to the director asking for the mining plan for the area because this is his own land. And pursuant to that, we apply, we are given environmental clearance, everything. They fix the price to be paid within a period of two years. We pay 60% of that already. They allow us to operate. We operated without any problem. It's a legal operation. And the stones are still lying there. And when we pay, they give us the challenge. The procedure is that we extract, then take it away. At the check gate, they determine the extent to which we have taken out, and the challan is then given to them. That's the procedure. So they have already received the money to the extent of about 60%. Out of 90 lakhs, we have paid about 50 lakhs in all.
If grants with some indulgence, my lord, I have a copy of the affidavit, which is being filed, my lord.
No.
Which may kindly pay you, sir.
No, you have not given us
In
copies.
Process of filing, in process of filing.
Our process of filing is different.
In this case,
The other case, my lord, will cover everything, my lord.
No. Let us not confuse the
Because,
thing.
my lord, the very order which they are seeking now to the interim order, we are responding to that case, my lord. That Bronson Terran.
where is the Supreme Court order?
That's why I was seeking indulgence. That's why
The whole problem is, my lord,
No, what is this case? 6. Here an affidavit is there.
by
We have filed the affidavit, my lord. On merit also, lordship can look into, my lord, case 36 of the writ petition. Case 36, my lord. On merit also, my lord, case 36.
now let me complete then, if you are going to argue
Okay.
on merits, let me complete it. Page 36 is the environmental clearance. Your lordship has seen the letter from DFO to the director. This is the environmental clearance and that pursuant to which we operated. Because we are legally entitled to operate and we have operated. Our goods are, extracted goods are there at the time when the suspension order came without notice. And if your lordships kindly have a look at page 44, this is a letter from the DFO itself to the Deputy Commissioner Karbi Anglong. Kindly see. With reference to the subject cited above, I have the honor to submit herewith the details report of the issuance of no objection certificate for blasting operation at Naupani, so-and-so, Stone Quarry, which is
Page.
page 44, Milord.
Yes. Yes.
Your lordship has gone through the first part.
Yes.
As per report of the concerned Assistant Conservator of Forest Northeastern Region, Park Up, letter number so-and-so under reference, the details reports are given below. The mining sites are outside 10 kilometer of eco-sensitive zone of the southern boundary of Kaziranga National Park, and there are not river streams or rivulets in the vicinity of the proposed mining area which flows into Kaziranga National Park. The mining sites are outside from parts of the 9 identified animal corridors as directed by the Honorable Supreme Court. The minimum distance of the proposed blasting site from the nearest school is 4 kilometers. Minimum distance from hospital 8 kilometers. Minimum from the nearest village is 1.5 kilometers. The mining site is approximately 15 kilometers away from the national highway. There are no any electric transmission line, heavy traffic load, and the site doesn't recognize as no development zone. Besides, there are no any permanent elephant corridors and the area falls outside so and so. This is submitted for your, this is Then the same letter is also sent to the SP Miller at page 45. It is very clear that it is beyond 10 kilometers of the boundary of the sanctuary. And 46 Miller, the no objection certificate is issued from the district magistrate. And 4950, your lordship sees the receipts for the challans. We have paid the money. Page 49, Miller. It is dated 7/6/24. Please fine enclosed treasury salon number so and so, SBI so and so for 22 lakhs in lieu of second case. First case already we have paid. This is the second case. And also a late fine of so much and only deposited so and so. And again, the above mentioned Mahal for adjustment in your cash account, please point out credit due course. So the payment is received and page 50. Your lordship sees the challan in cash, recording the fact of the payment of further 22 lakhs 50. And at page 52 is the challan is your lordships who have paid it, your lordship will kindly 24/6/24.
Where is this proposed all this
Bigger pardon.
proposed? What is the proposed eco-sensitive zone?
Proposed eco-sensitive zone is something, my lord, which is from the border of the sanctuary, there has to be a gap. That is the buffer. Eco-sensitive zone is referred to that buffer.
Is
And
there any report regarding that proposed?
yes, my lord, the Supreme Court has clarified that. If your lordships remember, the first case was by Justice Lokul, where he said it has to be 10 kilometers. Then two Supreme Court subsequent judgments clarified the position that it is only 1 kilometer from the border of the existing sanctuary. So that is the eco-sensitive zone now. That has been accepted and the earlier view has been dissented from. So the net effect of eco-sensitive zone is from the sanctuary boundaries. For 1 kilometer, you cannot have any industry or any installation so far as the area is concerned. So eco-sensitive zone is now fixed to be 1 kilometer from the boundary. Therefore, that is the zone. We are not there. As your lordship has seen from the letter of the DFO, we are 10, even if you go by Justice Lokul's judgment of 10 kilometers, we are beyond that.
At this juncture, there are two categories of this 1 kilometer. What my general senior has said, my lord, it's area specific.
Let us not.
Different order, my lord, which says.
Let us go one by one.
I'll
give you time.
Let us not confuse all these issues. The issue so far today is concerned, I am asking for a little interim prayer. What is my prayer? You have allowed, admittedly, me to operate. I have operated. You have accepted the money I have given, which you have fixed. That is lying there. And I am praying to the court that this is the situation. At least let me take away the goods. the stones. You have already accepted the money. This is a legitimate operation. You are under your own orders.
So what is the stand in the affidavit regarding proposed that eco-sensitive zone?
They are not saying anything. So far as eco-sensitive zone
There
is
is already,
concerned, they have given a proposal which is yet under consideration.
Yes, Mr. Sutia, you have an affidavit on record. What is the stand?
Eco-sensitive zone, my lord. It is the government of Assam sending it to the Ministry of Environment.
No,
and
in
Sewage.
your affidavit, is there something?
Nothing.
My lord, in
Is
our-
there any, my specific query is in your affidavit, is there something regarding the area of proposed eco-sensitive zone? Which paragraph?
Our stand is that our government of Assam issued the notification to the Karbi Anglong Autonomous Council in pursuance to the order passed by the CEC. Accordingly, we are following the order passed by the state government, my lord. We have annexing
No,
all the documents. my lord.
My specific query is that, is there anything about proposed eco-sensitive
Yes,
zone
my
in your affidavit?
My lord, my lord,
Have they said anything? No.
my lord. Lordship will look
Yeah,
into,
no.
my lord.
In fact, my lord, in one of
Lordship
the
will look into it, my
cases,
lord.
we have
Paragraph 12.
indicated
Paragraph
that
12.
the area which is shown in that case,
Paragraph
I
12 and 13, Lordship
remember.
will look into it, our affidavit. They will look into it.
Respond number 15.
Is the CEC.
13, my lord. I am, I
Huh?
think. Affidavit was filed, my lord, on behalf of respond number 13.
13.
13, Division of Forest.
Who has written to the director, my lord, asking for his
Divisional
findings
Forest
there.
Officer.
My lord.
Huh?
And he has himself written in that
Huh?
letter that it's beyond 10 kilometers.
Respond number 13. Who is this respond number 15?
Is the CEC they are talking
My
of?
lord.
Huh?
CEC, my lord.
CEC means?
Central Empowered Committee. Central Committee is appearing, my lord. CEC is a body.
That you have said.
Yes.
Which paragraph?
CEC, my lord.
No, in your opinion.
Paragraph 12, my lord. 12 and 13, lords will look into it.
Hmm? এইটো কোনটো আছে? Gauhati has been to do. মোক দিয়ে এইটো paragraph-টো উলিয়াই দিম। যিটোত 1 কিলোমিটাৰ বুলি ক'লে। এতিয়া সেইটো
Paragraph 12
Regarding, my lord, Supreme Court's order, my lord.
order.
And paragraph 13 is, my lord, regarding the project elephant, my lord, that is the.
But there must be detail of the.
My lord, lordship will look into, my lord, regarding, eco-sensitive zone, my lord, that is paragraph 18, page 132. Earlier, it was not submitted to us. It was submitted to us on 16/12/2024.
No. Where is the proper description?
My lord,
Where is the proper description?
that description is with the government of Assam, my lord.
Because DFO is writing definitely without
Hello.
some or without.
My lord,
He is not writing the letter without any meaning.
My lord, that is.
That is why I.
My, you clarify it, my lord. And before
This
that also,
this
my lord,
letter, as pointed out,
my lord,
page 44.
44.
It's definitely writing with some meaning.
My lordship will look into first, my lord, lordship page 36, my lord.
Yes.
Page 36, Lordship, just a moment, but Lordship look into. Page 36. Lordship will look into the date. Environment clearance certificate date is 17/6/2023. 17/6/2023. Then Lordship look into my lord. Page
17.6, where it is, you can.
In the last my lord, near the signature, Indeswar Kolita, date 17/6/2023. The valid EC is required. Lordship will look into page 42 now. Paragraph 8, my lord. For passing the interim order, my lord, the environment clearance is valid for a period of 2 years, my lord.
2 years of gate to
We are on
My lord,
25.
Lordship look into it, my lord. Thus, it is EC environment clearance certificate is valid for 2 years, my lord, from 17/6/2023, and it has been elapsed in 2025. When the writ petition was moved, there was no interim order. And all the other cases, writ petition, maintenance of the writ petition kept open, and it decided that it will be heard along with the affidavit filed by the, my lord, respondent, my lord. And we have, my lord, submitted that particular order, my lord. The details order has been passed regarding the whether maintenance question is kept open. So without passing, my lord, in case interim order, lordship may heard the whole data, my lord, on any date, my lord. We have filed the affidavit. Government is also filing the affidavit.
But nobody is pointing out what is the proposed,
Advocate is there, my lord.
proposed,
Yeah.
I mean, asking about the proposed eco-sensitive zone to the respondents time and again.
Clarify. And and short, my lord, Kaziranga, initially we fixed my lord, EHZ, back EHZ. Then it was aligned, my lord. Now, as of today, my lords, we have sent the proposal to the proposal is under preparation, my lords, and there are two categories of, my lords, issues are there, my lord. Two issues are there. Supreme Court says in those which have been given approval.
Tell me firstly and clearly, what is the eco-sensitive zone proposed?
My lord, that is under examination, my lord.
Then, do you know in a criminal case,
My lord,
preparation, attempts and
it
commission?
is under preparation.
So with preparation, what kind of preparation?
My lord, it was realignated. Some areas are excluded, some areas are brought in. Earlier proposal has been taken back.
Taken back. So as on there, nothing.
Nothing.
It is 10 kilometers because Supreme Court order says.
Where from you are saying?
But
Nobody is.
judgment, my lords, I'm bringing on that is the reason I'm.
That
I'm
is the
insisting on that.
problem,
Actually, it
Milord.
has to come.
That is the problem. 10 kilometers was Justice Lokur. 2 judgments came thereafter. One is by Justice Bose. The third is the judgment of Justice Gauhati, where the entire thing has been examined, and now they say that it is only 1 kilometer.
No.
And why 10 kilometer cannot be put, that has been explained there. And finally, they say that it is only 1 kilometer is the eco-sensitive zone from the board.
Is it part of the record?
Yes, my lord, the judgment give you a lot.
1 kilometer is minimum. But in those cases where there is no.
And they have not,
Kilometers.
they have not, as of today, any proposal sent so far as state of Assam is concerned to the central government. The one which was sent, it was returned back and they have not sent again.
The very judgment Lordship is holding, Lordship has to read the whole thing. It's not as simple as they're saying that 1 kilometer, 1 kilometer. No, my lords. Those centuries where there is no proposal, 10 kilometers, my lords.
You have, the Assam government has not sent any proposal which is pending with the state central government. That's the present factual position. We should not try to give a wrong impression to the court. This is, my lord, the final position. That is, my lord, Justice Gauhati, Vikram Nath and Sanjay Karol. And they have, if your lordships kindly turn, it's a long judgment I can read, but conclusion is at page 65, paragraph 65, my lord. A2 Kuntu. Arjun to motion. The principally, my lord, there are three judgments. One is a judgment of Justice Lokur. The next case is the Bose 22, and 23 is Justice Gauhati's case. Judgment which has modified the entire position, and he has discussed the earlier two judgments, and finally it has come to the view which your lordships will find at paragraph 60, internal page 30 if it is SSC, no? May I place para 60 below? Insofar as the restriction on mining is concerned, we are of the considered view that it has been the consistent view of this court that the mining activities within an area of 1 kilometer of the boundary of the protected areas will be hazardous for the wildlife. Though in the case of Goa Foundation, the said directions were issued in respect of state of Goa, we find that such directions need to be issued on pan-India basis. We are therefore inclined to allow the present IA direction in paragraph 56(1) of the order dated 3rd June 22, that is of Justice Bose, my lord, is modified and clarified that the directions contained therein would not be applicable to the EASZs in respect of which a draft and final notification has been issued by the MOF and CC, and in respect of the proposals which have been received by the ministry. We, however, direct that central government publicity should be given to the draft notification which is required to be published under the rules of so-and-so. We further direct that final notification to be published under clause D of sub-rule 2 of rule 5 of 86 rule shall not be given effect for a period of 30 days from the date of issuance thereof. We don't have to have the consider this because the draft proposal has not gone to the central government so far Assam is concerned. It is further directed that any person who is aggrieved with such a final notification would be entitled to approach this court directly by filing an application in the present proceedings. We further clarify that the direction contained in paragraph 56 of the order dated 3rd June 22 would not be applicable where the national parks and sanctuaries are located on interstate borders and share common boundaries. We also modify the direction contained in paragraph 56(4) of the order dated 3rd June 22 and direct that mining within the national park and wildlife sanctuary and within an area of 1 kilometer from the boundary of such a national park and wildlife shall not be permissible. This is the conclusion. Para 65. The Justice Bose's judgment, the second judge also has been modified to that extent.
What is this paragraph 56 they are referring to time and again?
Yes, my lord. In Justice Bose's case. We also modified the direction contained in paragraph 56(4) of the order dated 3rd June 22.
Well, I have that now. That 3rd June, my lord. There's a paragraph H.
And direct that mining within the national park and wildlife sanctuary and within an area of 1 kilometer from the boundary of such a national park and wildlife sanctuary shall not be permissible. You cannot mine within the sanctuary, obviously. The question was how far it will go from the boundary. Finally, in para 65, they have now come to a conclusion that the mining within the national park and wildlife sanctuary and within an area of 1 kilometer from the boundary of such a national park and wildlife sanctuary shall not be permissible. And your lordship has seen the DFO's letter to the two authorities that it is beyond 10 kilometers of the boundary. So in either view, this problem doesn't arise so far this case is concerned.
This is periodic Pata land.
Yes, this is purely Pada. Therefore, what has happened? We have approached them that we want to mine in our own land. The DFO,
But so far interim period, it is to leave the.
only that, nothing more. No machines, nothing. Already they are lying for just one more year. And it is to do nobody's benefit. We have parted with the money for that. They have received the money. The people who are requiring this important material for construction work are suffering and prices are going up. That's what this court said in the first case. At page 118, Justice Bhuya, as he then was, noted that fact. We have mentioned it. At page 118, if your lordship sees that
Okay,
judgment.
we'll take up day after tomorrow to pass the order.
Okay.
Tomorrow, day after tomorrow.
Yeah.
Let me go through it so that
Yes, your lordships can just see this.
that 56 or that paragraph where it is appearing.
I'll counter on.
That is on.
On the road.
So to prayer is to leave the extracted material.
Absolutely that. Nothing beyond that, And that is on admitted facts, Mr.
56. 56, where it is appearing, Mr.
56.
Bora?
Yes, 2022 10 SCC 544.
Paragraph
56.
56.
0.4.
Those points are there.
Yes, yes.
This is which paragraph? Can you mark it? Just mark it.
Yes. Give some.
But my lord,
Whoever, maybe Mr. Sutia, this is not the, however high a committee may be, this kind of document cannot be taken into cognizance. Time and again, Supreme Court has said that nobody high an authority may be, one should not address any letter to the High Court. However high it may be, it cannot be taken cognizance of. One should be reminded.
So it is a point, the copy is marked to the deputy solicitor.
We don't know. It is addressed to the Registrar Gauhati High Court. How can it be? Then the presence of counsel is not necessary.
And
The Supreme Court has said one must be placed. Any document is to be placed only through the counsel. This is not the way. We are not taking into cognizance. Don't place this.
in fact, that is.
No, this is not the way.
It is equal to be pointed out, it is addressed to the deputy.
That we don't know. It is to the registrar.
And my lord, I have pointed it out, my lord, and it is, my lord, referred to me also.
That is a different
No,
issue. This is an, you place it on affidavit, that is a different matter. But don't place it any letter addressed directly to the Registrar High Court.
Milord, exactly, Milord. In another case, the same letter was placed, and that was my objection. That
Yes.
they are a party, they are writing about a High Court judgment and instructing High Court what to do and what not to do. That is.
This is not the
one
way.
should really so.
You place that, I'll make the comment. I'll make the comment on it.
Absolutely, Milord.
Day after tomorrow.
My lord, as my lord, it is addressed to the my lord. So I am only pointing out as it is.
No, you have to.
Father, day after tomorrow, lordship has to list those other matters also.
No, I am looking at this one only.
No, because this is, however,
Mr. Gogoi, I am looking at this one. Why you are broadening the scope now? let me have a look at this case.
Yes. Because the affidavit covers every issue. That was clear, right?
Now you bring your affidavit.
Let me go through this para
We
56.
are also relying on that particular
Their
judgment.
judgment is also relying, my lord.
We are also relying on that judgment.
The Supreme Court has not diluted, my lord. It's there.
Okay.
My lord,
The same judgment.
what is the activities that can be, my lord, carried out,
Hi,
my lord, because sensitive.
Mr. P.K.
We are also
Gustami,
relying on that.
Learned Senior Counsel, listed by Mr. B.P. Bora, Learned Counsel for the petitioner. Mr. D. Goyal, Learned Standing Counsel, Environment and Forest Department, and Mr. J. Sutia, Learned Standing Counsel, KAC, for the official respondents. For the respondent, KAC authorities, list the case again on day after tomorrow. Let me go through it.
Yes.
11-3.
11.
One last judgment is exhaustive and it has considered all the earlier two judgments. So that
This
is
Honorable Justice Gavai.
Gauhati judgment.
Will clarify. Public.
Gabriel.
Item number 33.
And your lordship is very right in your lordship's reaction, because I also submitted the same thing, that if a party writes a letter instructing the High Court as to what to do, then, my lord, I think your lordship will have to so much or take contempt notice against them. It's absolutely
Directly
unthinkable.
address করুন আলাই। Directly address করুন।
Deep level.
I think Mr. Bora, find out that the Ajmer Supreme Court has deprecated such practice.
Yes.
Find out, bring it. And our division bench also has deprecated such kind of practice. Throwing a document or writing directly to the Register High Court instead of placing it through council. Because that will be necessary for other cases also.
And
For the court.
Contents are also very objectionable in this.
Yes, Mr. Chakraborty.
My lord, this matter, my lord, perhaps my learned friend has something to say. In fact, this pertains to election of the municipal, erstwhile municipal board, now municipal corporation, where, my lord, the last elected body was in the year 2020. Since May 2020 till date, there is no election, although the mandate as per Article 243U of
Yes,
the
Mr. Dubey,
But I have got instructions in the matter.
have you filed affidavit?
No, but I have not filed my affidavit. My instructions are but we had taken preparations on last year also. In fact, because of change in events, this could not be held. There has been some.
Otherwise, is it permissible?
No. Something is such, but now in this case, state has also filed an affidavit. But indicating that, but because we had asked the state not to arrange for.
No, you filed the affidavit
uh,
1 week.
It was just weeks.
What
time.
is the Dharam or something? Some Dharam. Article 240
3U.
EU for municipality.
And A blood is the election.
Z.
And
yes,
for assembly or others?
Z. 243Z one. For
Yes.
other elections.
No,
That is different, my lord. Insofar as holding of election within 6 months from,
Dharam Pal or Dharam Bir, something like that.
I also.
my lord, it's referring to our High Court's judgment, my lord.
One
No,
is by Honorable Justice Koteshwar Singh.
No, yes.
6 months means 6 months.
6 months means 6 months,
Nothing else.
my lord. But that is not happening since 2020. That is the case.
File your affidavit.
Yes,
1 week,
10 days, madam.
10 days.
My lord, may I make one prayer, my lord? Since he is praying for 10 days, today is 9. The other matter that your lordship had taken before
There is a different issue, tax.
But my lord, the intermittent connection is because of non-holding of election, this arbitrary action by the executive officer of the municipal board in enhancing taxes. So my lord,
No, this is completely different. That is a
My lord,
different
my lord.
tangent, Mr. Chakraborty.
my lord,
D. Chakraborty. For the petitioner is present, Mr. Harduvel, and Standing Council, Assam State Election Commission. Appearing for the respondent number 4 has sought. Or already you took time many times.
Two times there.
I have got instruction.
Okay. Has submitted that he has received the necessary instructions to file the counter affidavit recently and has sought further 10 days time to file the counter affidavit. Full stop. Yes. Okay. What is your name? I'll list the case on so and so for filing a counter affidavit by the respondent 4.
2504.
It to 23rd. My lord, can this be also on 23rd, my lord, if possible? Oblige, 25th.
Don't mix
Well,
up the case
well.
issue. It will go for a toss.
No, my lord, oblige, oblige.
Item 34. My lord, on the last account, they were supposed to file the affidavit in opposition.
Nobody is present now. Mr. Gupta. Mr. A.R. Borua.
A.R. Borua.
Learned Counsel for the petitioner is present. Mr. The Learned Central Government Counsel for the respondents is found absent today on call. Full stop. In view of absence of the Learned Standing Counsel or Central Government Counsel today on call, let the case be listed again on so and so.
A date will be fixed for that. 2503. Item 35.
Respondent is supposed to file your affidavit, Lord.
Lordship, although I have not received the written instruction, but
Who is the main respondent here?
ultimately the fund has to be released from the revenue department.
Revenue department.
The district administration, Lordship, they have sent a proposal.
Yes. Do you have any instruction? Huh?
Have been received by the department. Certain documents has been asked for from the district commissioner. That have not been received.
And Miss say you are the main respondents. Huh? The work was executed. What is the
Yes, sir.
contract work? Where is the contract work?
Lordship,
Where is the work order?
Lordship work order at page Lordship. Annexure 2 Lordship,
Hemaji,
Lordship. Page 18 Lordship.
18.
Yes, Lordship. It should be the
By executive
executive
engineer.
engineer, Hemaji Water Resource Division, Lordship.
Then
You were supposed to file a affidavit, Lordship. As for the last.
if you don't have a rule, clarify it. Clarify it by affidavit. You have sent for vetting. Really? Okay, when you file? You are filing it today? Good enough, let us have it. No?
1 week time.
1 week time. BK Gogoi, petitioner. As Dr. Revenue, আগৰটো repeat কৰি দিব। আৰু আগৰখিনি repeat কৰি দিব। Miss A, Learned Counsel, appearing for the respondent Water Resources Department has submitted that the draft affidavit has been sent for vetting and the same will be filed within a week's time. Full stop. She has just sought for a week's time. She has just sought for listing of the case after a week. Post of the price list the case on so and so.
2003.
For filing of counter affidavit by the respondent Water Resources Department of Office. Let them file it.
36.
30 is same, Lordship. Issue is same.
Huh?
Lordship. Work order
Item?
amount is different,
36.
Lordship.
Okay, same.
Obliged, Lordship.
Item 37.
Yes, Mr. Chaudhary.
My lord, here, my lord, this is regarding settlement of.
Where is Fishery Department?
They have issued out.
They have issued the order. Heard Ms. S.B. Chaudhary, Learned Counsel for the petitioner, and Ms. Udas, Learned Additional Senior Government Advocate for the respondent number 4. Post op. Miss S. Setia, Learned Standing Counsel, Fishery Department, who on 4/2/2026 sought 3 weeks' time to file the counter affidavit on behalf of the respondent number 1 and 3, is absent today on call. And no counter affidavit has been filed on behalf of the respondent number 1 and 3 till date. First stop. In view of absence of the learned standing counsel, Fishery Department, let the case for ends of justice be listed again on so and so.
2003. Item 38.
May I please, your lordship?
Yes,
Let's speak for instruction, lordship. The case is lordship, challenging lordship to
this
order.
is for which department?
Forest lordship,
Uh-huh.
BTC.
Forest,
Forest BTC lordship,
BTC.
BTC.
Yes, BTC. Waited.
Lordship. Actually, I also file a writ petition lordship. After disposal lordship, file contempt petition lordship. And during pendency of the contempt lordship, they have passed an order lordship. And I filed, I challenge this order by issuing order which was passed by British authority 2011-25 lordship.
This is the second date only. Will
Yes,
keep
Lordship.
some time. J.U. Ahmed, petitioner.
Yes.
And Miss C.R. Mohilari, Learned Counsel representing the respondent BTC authorities for the respondent number 2 and 2 to 5. Post of. Miss Mohilari has submitted that she has not yet received the necessary instructions as regards the outstanding dues of the petition. Post of. She has thus sought for listing of the case after 2 weeks. Post of. The prayer is allowed. List the case. But this is a second round of litigation.
Yes, lordship. That is why I am saying lordship.
Hmm.
Part payment lordship. Already they made payment lordship partly, but during pendency,
On
they
6/2/2026, the Learned Standing Counsel BTC was asked to obtain instruction by today, as this is a second round of litigation. Post of. Yet, the Learned Standing Counsel BTC has failed to place the necessary instructions. Perhaps will list the case again for on so and so. We can observe, first it is observed that in the event the instruction or affidavit is filed on behalf of the respondent BTC authorities, the petition will be taken up for consideration, keeping into consideration the doctrine of non-traverse.
6/4, 6th April.
God bless.
Item 39.
Non-payment of vehicle bill, lordship, we need some further time to obtain our answer.
Okay, Mr.
A. Hussain.
A. Hussain, petitioner is present. Mr. S.R. Bulwa, Learned Junior Government Board, some for all the respondents, has sought for and is granted further 3 weeks' time to obtain the necessary instruction and to file the counter affidavit. Post of. Place the case on so and so.
Item number 40.
Instructions is awaited lordship. Others.
আগত Mr. P. Bora লিখিব, P. Bora petitioner. Ms. T. Bora, Learned Standing Counsel, Health and Family Welfare Department. আগত Mr. 3 weeks' time. 6 4.
41 is same.
Same.
Next to same.
इसी पे instructions and file में इसके.
Okay, next to you.
41 to his.
P. Bora, Learned Counsel Board petition is present. Ms. D. Bora, Learned Standing Counsel, Health and Family Welfare Department, paying for the respondent, all the state respondents, has submitted that the necessary instructions have been received and given how much time? 2 weeks' time. The counter affidavit will be filed. Post of. The prayer is allowed to raise the case on so and so for filing of counter affidavit by the responding authorities.
6th April. 6-4. Item number 42.
Allow
Yeah, please allow.
Korea Enterprise. Yes, non-payment.
Yes.
Non-payment. Yes, madam. Not given. Fired Mr. T. S. K. Learned Counsel for the petitioner, Miss B. Sohri.
On behalf of
Okay, Learned Counsel on behalf of Mr. J. Oh, you're for KAC. Okay. On behalf of Mr. J. Sutia, Learned standing on
Right in
KAC for 23567. Post of Mr. SK has, Mr. TSK, Learned Counsel for the petitioner has handed over extra copies of the writ petition to Miss So-and-so. So Miss So-and-so has paid for and is granted 3 weeks time to obtain necessary instruction and to file a counter affidavit. The prayer is allowed, release the case on so-and-so.
8-4. 8 April. Item 44.
Wait, please, your lordships.
Additional evidence, we have the affidavit. Yes, sir.
Lord, we had filed an affidavit, Lord.
Regarding what?
Lord, service, Lord, there also we have annexed the tracking report, Lord, by which the service has been completed upon respondent number 5. And Lord, we have also made a statement to the effect, Lord, that we went to the office of respondent number 5, Lord. They did not receive, Lord. Thereafter, they have a local office at Gauhati. There also we have served through courier. And we have also.
So regarding service?
Yes. And Lord,
Okay.
today we have filed an additional affidavit which we have
Okay.
brought on record. If your lordship kindly have a look,
No,
Lord.
no, I don't go through it. I put it in the Lawajima court. I put it in the Lawajima court to place a report regarding
Only
service. I
difficult-
don't go through. I don't go through.
Well, only one aspect, the additional affidavit which I have filed, Lord, if I can place before your lordship for you, just a moment.
Regarding service?
No, no, Lord. Today we have filed, we have taken permission. from your lordship. My lord, kindly have a look at page 236, my lord. My lord, on lordships on 12-2, my lord, your lordship was pleased to issue notice of motion as well as notice on interim prayer. And my lord, on that very day, your lordship sees this work order that has been issued in favor of respondent number 5, my lord. My lord, kindly have look at copy 2, at the bottom, my lord. Number 6. The executive engineer Jorhat, PWD Jorhat leader for information enclosed tender agreement so and so original. At serial number 2, your lordship would see performance security in the form of TDA, term deposit advice, number so and so dated 9/6/25 for an amount of rupees 1,25 lakhs. In terms of 33(1), my lord, after acceptance within 15 days, they have to deposit as performance security. 5% of the amount, which would come to around 70 lakhs. What the respondent number 5 has done, my lord, they have, and the respondent number 3 had accepted this deposit, which is a backdated one, my lord, in 19th June that has been issued. The tender process which has completed in 2026. 31st December was the last date of my lord.
Performance security in the form of term deposit advice.
My lord.
That is dated 19/6/2020.
25.
The fixed deposit can be of 5 years.
My lord.
That can be of an earlier date. But it should be, in terms of the clause, my lord, it should be the name of the executive engineer. But it's not per se term deposit. If your
Where
lordship,
is the performance security clause?
yes, yes, just I'm showing your lordships, my lords. Kindly have a look at page 45, my lord. Had it been a simpliciter FD, my lord, one can understand. But what is the requirement? The lordship would see at clause 33.1. Within 15 days of receipt of letter of intent, the successful bidder shall deliver to the concerned division performance security in any of the form given below for an amount equivalent to 5% of the contract price plus additional security bids in accordance with clause 29 of the ETB for details. My lord will see a bank guarantee. Here the second would come to play, fixed deposit in the name of executive engineer PWD so and so from any nationalized bank. So it has to be earmarked for that executive engineer. It's not a simpliciter term deposit that can be given, my lord. And your lordship has also seen the amount. But our allegation is, my lord, this has only been done to backdate that work order, my lord.
Okay, let it be placed in a next week with a report. Then we'll proceed ex parte against respondent of fine.
My lord. And can your lordship be
Hi.
pleased to call for this, my lord? Uh,
Your counterpart is not available,
but my predicament is, my lord,
call Mr. Gogoi.
my lord, I am calling, my lord.
Supplementary list, item 52.
এখন কি? এখন ক'ৰ পৰা আহি গ'ল মোৰ তাত? মই ভাবিছোঁ এইখন লিখিছোঁ। হা? মই এইখন দেখি আছো বোলে আৰু ক'ৰ পৰা এইবোৰ আহি গ'ল? Yes.
The logic, kindly have a look on the order dated 6/2, my lord. 26. Report directed to the respondent number 1 and 2 take instruction.
Mr. Kotoki, you have to do, people are not
And
very,
Next.
not very enterprising to attend the courts in the second half. In the second
It's
half,
very-
people are very showing reluctance.
Reluctant.
Ah.
It is new trend, my lord.
New trend.
My lord,
People are
we are-
reluctant to,
My lord, very easy going in the court.
very easy.
That's the difficulty nowadays.
File that.
No, the government has filed
You have
a.
filed affidavit.
Hello.
Let us see. What is the case about?
You know, the tender notice was issued on 4/3/2017.
Who has filed? Additional district commissioner.
Well, the government is.
Standing Council Fishery. Miss S. Setia.
Yeah. Or any other day, my lord.
Whatever, this process is to be brought to a logical conclusion either through cancellation or through award.
Yeah.
Whatever. That
They are also in difficulty. They are holding the award
and your earnest money
is
is
lying with them.
lying with them.
Let it be any other.
Is it Miss Setia or
Should be.
Yeah.
Sutia? People don't attend the court after 3 o'clock.
Look, we are oldest person, Musoli Sayola and me here.
Yes.
We are.
Thanks you that government side.
Mr. S. Kotoki, learned counsel for the petitioner, and Miss U. Das, learned additional senior government advocate for the respondent number 3 are present. Post op. But despite call, the learned standing counsel, Fishery Department, for the respondent number 1 and 2 is found absent today on call. Post op. Para on the previous date of listing 6/2/2026. Miss S. Chutia, learned standing counsel, Fishery Department, sought further 1 week time to obtain instruction as regards any decision taken in respect of the proposal for settlement of fishery number 25, Kotakhali River Fishery, District Borpeta, pursuant to the proposal forwarded by the District Commissioner Borpeta as far back as on 28/3/2017. Full stop. In view of noticing, recording the absence of the learned standing counsel and non-filing of counter affidavit by the respondent number 1 and 2, comma, list the case on so and so, or full stop, on the next date, comma, the case will be, the repetition will be taken up for final consideration.
2002.
Even in the event, even in the event of full stop, invariably.
Item 53. May I please your lordship, my lord?
Non-payment.
Non-payment, my lord. Only 3,52,000 is pending.
Yes.
And
Somoria is absent. He is also reluctant after 3 o'clock.
can it be, my lord, because March?
Right. And then B. Chaudhary, learned counsel for the petitioner, and Miss B. G. Bora, learned standing counsel, Agriculture Department, for the respondent number 5, 4 and 5, of
What?
1, 3, 6, and 7 are present. First of, however, despite call, the learned standing counsel, Seed Corporation,
Yes, ma'am.
Assam Seed Corporation,
Assam Seed Corporation.
for the respondent number 4 and 5,
4 and
is
5.
found absent today on call. RM Bolwa, please. To liquidate forest, sorry, finance. Place the case again on so and so.
My lord, March 16, my lord, another matter has been fixed, my lordship.
16, okay,
Same
16. Okay, বাকি এটা orders পিছত দিব। এইকেইটা দিয়ক, admission আছে ন? এই air ভূঞা,
Time being matter. Item number 20.
RP Act. Heard Mr. A.R. Mia, learned counsel for the petitioners. Union of India, Miss A. Gayon, learned central government counsel for the respondent number 1. Mr. A.I. Ali, learned standing counsel, Election Commission of India, for the respondent number
2, 4, 5, and 6.
2, 4, 5, and 6. Mr. S.R. Borua, learned junior government advocate Assam, for the respondent number 3, 7, 8, 9, and 10. First stop. Para. The petitioners, comma, 5 in number, comma, have joined together to institute the present petition under Article 226 of the Constitution of India, stating that they have a common cause of action to espouse. Dosto, para. From the same family or different families?
Same family, same family.
Same family.
My lord.
Okay. The petitioners have stated that they are members of the same family, and since for a long period of time, comma, they have been exercising adult franchise, right? Adult franchise.
Adult franchise as a voter, my lord.
Adult franchise. They're exercising their right to vote
My lord.
in
Uh,
both legislative assembly, state legislative assembly election and stroke or parliamentary elections.
my lord.
Full stop. By virtue of their, by virtue of by virtue of on the strength of by virtue of enrollment of their names as voters in the electoral rolls. Full stop. All the voters, all the petitioners had voted in the previous, the petitioners have claimed that all of them had voted earlier in legislative assembly election in elections to the state legislative assembly and stroke or parliamentary or the parliament as voters from number 34
My lord.
Demoria within bracket SC legislative assembly constituency district Kamrup Metro, comma Assam. Post. Where are your EPIC numbers?
My lord, yes.
Any mention somewhere?
Yes, my lord, over here.
Paragraph?
Page number? My lord, maybe please to find, starts at page 37, my lord. Page 37, annexure 3, my lord.
Madam, you write the EPIC numbers.
You take it.
The petitioners were issued e-electors photo identity cards, E-EPIC. They have numbers also.
My lord.
And they bear E-EPIC number.
Numbers.
So and so, so and so, so and so, so and so, and so and so respectively. Write down. Full stop. এই আমার নতুন ইলেকশন নোটিফিকেশন আছে প্যারা মিস্টার ভুইয়া learned counsel appearing for the petitioners have submitted that the petitioners have come to learn that in the electoral rolls published after the recent exercise
Special revision, my lord.
of special revision initiated by the Election Commission of India their names are not included in the electoral roll full stop. Mr. Bhuya has submitted that even in order to delete the name, in order to delete the name of a person of a voter whose name was included in any in the previous electoral roll, such a person must be given a prior opportunity of being heard. Full stop. But none of the petitioners was afforded any opportunity of being heard. Full stop. Mr. Bhuya has submitted that the deletion of the names of the petitioners is perhaps attributable to an eviction
Drive carried out.
drive carried out in and around
Particularly in Sunapur area, I mean.
in and around the area where the petitioner have been residing for a long period of time, exercising their right to vote. Full stop. The respondent authorities in the state government had carried out an eviction exercise, eviction drive in and around the said area of Sonapur area, on the ground that the area comes under Chapter 10
Chapter 10 of the.
of the Assam Land and Revenue Regulation 1886. As there is restriction stroke prohibition for acquiring status of landowner in a tribal block stroke belt declared under Chapter 10 of the ALRR 1886, confining to specific category of persons, the petitioner were unjustifiably taken within the purview of the eviction drive. First off, but a number of litigation ensued thereafter. First of lastly, the Honorable Supreme Court of India in
my lord, in contempt petition, civil annexure, my lord, is at page 22, annexure 1, my lord.
in page 22. In contempt petition civil diary number page 22, 44449/2024, by an order dated 39/2024, directed the parties to maintain the status, as on that date. It is by virtue of the said status quo order, the petitioners are still continuing to reside in the locality, in the areas mentioned in their respective EPIC. Right?
Yes, my lord.
As such, he has thus contended that the respondent authorities have acted illegally and arbitrarily to delete the names
of the petitioner from the electoral roll. This is your case?
Yes, yes.
Full stop. Mr. Ali, Learned Standing Counsel, please take your seat. Remind me if I go wrong. Learned Standing Counsel, Election Commission of India has submitted that ordinarily, comma, before deletion of any names, comma, from of a person from the what do you say?
Electoral roll.
Electoral roll. Such a person is to be given a prior opportunity of being heard, and deletion of any deletion of name can only be made after proper verification of facts.
Yes.
Full stop. He has submitted that the petitioner has alleged that no prior and reasonable opportunity of being heard was given to them prior to deletion of their names from the electoral roll. Full stop. If such a position, comma, assuming such a contention as correct, then the petitioner has a statutory remedy of filing a filing an application under Section 23 of the Representation of the People Act 1950, and thereafter appeals under Section 24 of the RP Act 1950. Full stop. Para. In the state of Assam, under subsection 3, in subsection 3 of Section 21 of the RP Act, comma, which is with a non-obstante clause, comma, the Election Commission may at any time, comma, for reasons to be recorded, comma, direct a special revision of the electoral roll for any constituency or part of a constituency in such manner as it may think fit. Full stop. By notification dated 17/11/2025, right? The Election Commission of India directed a special revision in exercise of the powers under Section 21 of the RP Act, comma, with reference to 1/1/2026 as the qualifying date, comma, in the state of Assam. Full stop. Para. Section
22, Section 23, and Section 24 of the RP Act have provided as under. Good corridor. From the provisions contained in Section 22. It is evident that if the electoral registration officer for a constituency in the election, if any deletion of a person's name from the electoral roll is to be made on the grounds mentioned in A, B, and C by the electoral registration officer, by the jurisdictional electoral registration officer, then such deletion can only be made only after giving the person concerned a reasonable opportunity of being heard in respect of the action proposed, that is, deletion, to be taken in relation to him, that too, after proper verification of facts in such manner as may be prescribed. Full stop. Section 2 within bracket small h of the RP Act as per section 2h of the RP Act, quote unquote, prescribed means prescribed by rules made under the RP Act. Full stop. Para. In case as per provisions of section 23, any person whose name is not included in the electoral roll of a constituency may apply to the electoral registration officer for the inclusion of his name in that roll. Full stop. The electoral registration officer shall, if satisfied that the applicant is entitled to be registered in the electoral roll, direct his name to be included therein after proper verification of facts in such manner as may be prescribed. Full stop. It has been provided that if the applicant is registered, not required, no amendment, transposition or deletion of any entry shall be made under section 22, and no direction for the inclusion of a name in the electoral roll of a constituency shall be given under section 23, after the last date for making nominations for an election in that constituency or in the parliamentary constituency within which that constituency is comprised and before the completion of that election. Full stop. Para. In the case in hand, the election in the state of Assam has not been declared till date. Full stop. As such, there is no question of expiry of the last date for making nomination for any election in number 34, Nimoria SC constituency. Therefore,
it is within the right of the petitioners to make an application under section 23 for inclusion of their names in an electoral roll before the jurisdictional electoral registration officer as, according to a petitioner, their names were unjustifiably deleted from the electoral roll. Full stop. What is the concern rule? The
For inclusion of name, Lordship.
Page two,
Yes,
21,
Lordship.
rule, no.
page 151.
It is rule 26. Rule 26.
Please correction, Lord. Correction.
Under section 23, the registration of electoral rolls, right? 1960.
Yes, Lordship. Thank you.
Have contains are framed under the RP Act. Full stop. Rule 26 has provided for correction of entries and inclusion of names in electoral rolls. Full stop. As per you go to the prescribed form, right? Sub-rule 1 of Rule 26 has prescribed for the forms for an application under subsection 1 of section 23. Full stop. As per sub-rule 3 of Rule 26, the registration officer shall, immediately on receipt of such application, direct that one copy thereof be pasted in some conspicuous place in his office, together with a notice inviting objections to such application within a period of 7 days from the date of such posting. Full stop. A mandate is contained in sub-rule 4 of Rule 26 to the effect that the registration officer shall, as soon as may be after expiry of the period specified in sub-rule 3, consider the application and objections thereto, if any, received by him, and shall, if satisfied, direct the inclusion, deletion, correction or transposition of entries in the rule, as may be necessary. Full stop. It has been, a mandate is also provided to the effect that when an application is rejected by the registration officer, he shall record in writing a brief statement of his reasons for such rejections. Full stop. Para. Section 24 has provided for appeals against any order passed by the jurisdictional electoral registration officer under section 23 of the RP Act. Full stop. A first appeal would lie to the district magistrate or additional district magistrate or executive magistrate or district collector or an officer of equivalent rank from any order of the electoral registration officer under section 23. Full stop. A further appeal would lie to the chief electoral officer, from any order of the district magistrate or the additional district magistrate under full stop. Para.
in view of such statutory provisions from the aforestated statutory provisions, comma, it is evident that if the petitioners are aggrieved by the deletion of their names from the electoral roll of number 34 Demoria SC constituency, comma, the petitioners have the statutory remedy of filing an application under section 23 within bracket 1 of the RP Act at first, and if at first, full stop, the jurisdictional electoral registration officer is cast with an obligation to pass a necessary order on such application within the prescribed time limit. Full stop. I am either allowing the application or rejecting the application. Full stop. If any rejection order is to be passed, then such order must be uh, if an application is to be rejected, then the electoral registration officer shall have to record record in writing a brief statement of his reasons for such rejection. Post stop. If in the event the application of the petitioners are rejected, are rejected, then the petitioner has the options or statutory remedy of filing appeals under section 24 of the RP Act. Full stop. In view of presence of such alternative, adequate, efficacious, and statutory remedy, comma, this court is of the considered view that the petition is not to be entertained at this stage. Full stop. Full stop. As reserving, comma, reserving the liberty to the petitioners to avail the aforestated remedy as expeditiously full stop. Mr. We need how many days you can file?
I can file within a week.
The petitioner. Full stop. তাৰ আগতে দিব আপোনাৰ তেতিয়া entertain not to be entered reserving the liberty তাতে লিখিব Mr. Bhuiya, learned counsel for the petitioner has submitted that the petitioners have all the supporting documents to support their claim that their names have been unjustly deleted from the electoral roll of published for number 34 Demoria SC LAC District Kamrup Metro Assam, and the petitioners are in a position to file such an application under section 23(1) of the RP Act within the period of 1 week from today. Post up. It is observed that if the petitioners submit their applications under section 23(1) of the RP Act within a period as stated on behalf of the petitioners, as stated by the learned counsel for the petition on behalf of the petitioner, comma, the jurisdictional electoral registration officer shall consider such application in terms of the mandate contained in section 23 read with rule 26
23 of the RP Act, read with Rule 26 of the rules.
Registration rules.
Sorry, RP Act, read with Rule 26 of the so and so. So that the applications are considered within the statutory time limit.
My lord. Highly and deeply obliged, my lord.
Right?
My lord.
Full stop. If the petitioners are still, full stop, and if the petitioners, if after the decision of the decision of the electoral registration officer, the petitioners are find themselves aggrieved in any manner, the petitioner should avail the statutory remedy under section 24 of the RP Act.
My lord. Highly obliged, deeply obliged.
Clarify the position.
Huh?
It will deeply clarify the position.
Ah.
It will resolve many.
I'll just, because there will be some fact finding
Mal.
thing is involved, one line I'll add somewhere.
Mal.
Because otherwise,
I know.
because whether your names are there or not, affidavit will come and it will take about
Mal.
long time.
Mal.
Huh?
Mal, this,
Streamlined by lot.
So it is a serious issue.
serious issue, my lord.
So let it be done.
Many evicted people are, my lord, now this.
So you file your all the supporting documents.
My lord.
Give the time lot.
I'll just fine tune.
My lord. Highly obliged, deeply obliged.
Ah.
I think, don't worry.
Yes, sir. We will start, if not possible, conclude tomorrow.
My lord. My lord, here, my lord, what happened on the basis of a temper, my lord? We are given an order for supply of absorbent cotton, my lord. And we supplied the same.
Let us go by one documents so that I can remember.
My lord, that is page 30 is the e-tender, my lord.
38.
30, page 30.
Okay. E-tender,
E-tender.
rate contract for
Yes.
supply.
Supply.
Similar to that.
Yes, my lord. Same.
Okay.
Same. Huh? Now, page 55, my lord. This is the letter, my lord. The order was placed. That contract.
Take me to the relevant provisions also. Okay. The tender will be governed by Assam Public Procurement Act
Yes.
2017
Right.
and Assam Public Procurement Rules 2020.
Yes.
Okay. Then you emerge as
Page 55, my lord. This is the order.
two-bid system.
LY.
Two-bid system, technical price bid. Okay. Any provisions in the bid document
The bid document, they are not going to, my lord, here.
which are necessary to be looked into?
No, no, no.
Bid opening, financial bid. Oh, that L1,
Yes.
then parallel rate contract.
Right.
So you emerge as L1 or L2, L3?
L1.
L1. Okay, you emerge as L1.
And that contract was given, issued, my lord, for 1 year. Page 55.
One. Rate contract, okay.
Next.
Next is
Now, my lord, this is that contract agreement was entered into at
where page?
page 68. That contract agreement.
Page
68.
68.
That contract agreement.
Just a minute. What is page 61?
61
What is this?
is a
Annex?
part of, my lord, page 55, my lord.
Huh?
Letter of intent, page 55. That page 55, letter of intent, there is a part
Page
of.
55.
Yes.
Okay, this is LY. Yes. Gene surgical.
My lord, yes, sir.
Seal number 1.
Yes.
Date is
So that is 16/1/24.
16?
16,724, sorry. 16,724.
Would refer the please to select your company entering into rate contract. Yes. Essential drug, scope of work, it, security deposit. Is there, this is important or what? Product shelf life,
Not important. Not important.
page 57. You got something about expiry date, right?
Expiry date, my lord.
Relabeling.
Actually, my lord, expiry date is not-
Relabeling is there anywhere in the,
No.
no.
Relabeling, on the original product, my lord, relabeling. Product.
My lord,
So
that was-
you are for absorbent cotton wool IP 100-gram roll of 100-gram net
Yes.
weight.
Yes, my lord.
Page 61.
Yes. This is not,
Red.
this is not a drug, my lord.
Huh?
This is not a drug.
Not even drug,
My lord,
but medical thing
medical, because.
to be applied to
No,
patients.
medical equipment rules is there, my lord, in 2017. As per that, my lord, it comes under A, my lord, category A. And in fact, my lord, even the expiry date is not to be mentioned, my lord, some notifications are there.
But allegation is
Allegation-
one level is pasted over another.
But it says, my lord. But
We'll go to that. We'll go to
Yes,
that. Let us see the documents.
We shall come. Now, if you also see, my lord.
Your agreement, rate contract. This is page 68.
Page, yes, page 68.
17th July 2024.
Yes,
Right?
my lord.
Is there anything to be looked into?
My lord, I don't think, my lord, there, my lord. That contact. Only, my lord, there is page 71, my lord.
71. What is that?
That is, my
Rate
lord,
contract.
yes.
How many purchase orders were issued to you? Page 72.
Page,
Allegation is in respect of 2 purchase orders.
Page 72.
page 72.
Look at page 72.
Yes,
This blackened one or
black and one. Yes, these are,
this page 72.
Ah.
There is a chart,
yes.
Mr. Bora.
Yes, my lord, yes.
So this blackened kind of this 2 purchase order.
No, these are supply, my lord.
No, all are supplied.
Yes, yes,
All are supplied.
yes,
Question is about relabeling.
yes,
Yes, my lord. It is one purchase order, my lord.
Oh, no. Page 72, have you got it?
yes,
my lord.
Annex 4.
yes.
Yes.
There is table. 2 things are blacked.
Yes, my lord. Yes, my lord.
Where does because I am trying to lessen my work.
Yes, my lord. That is the allegation in respect of these
Okay.
Two,
purchase
two.
orders.
Okay, page 73. Is there any date?
Yes,
This is.
that is there.
What is there any number? 88027.
Yes.
Okay, this is 88027. 88027. Okay. Then
Then
another one,
76.
page 70.
Another,
109. Okay.
another order.
Okay. What are those? Page 80.
Page 80, my lord, it is the, my lord, the best production record, my lord. That was given by certificate analysis. That you will also find at page 81.
Page 80. These are batch production record.
Record
What does it indicate?
indicates, my lord, that they have been manufactured properly, and then, my lord, that was analyzed by my lord. That was at page 81 analysis.
Certificate of analysis. What are page 84?
82,
84, 84.
84. My lord, this is clearance certificate, my lord, given by them. My lord.
Clear certificate means?
Dispatch clearance certificate.
One delivered,
Yes,
delivered,
yes.
delivery complete.
After test, they're taking, this is delivery, dispatch clearance certificate only, my lord.
Dispatch clear, now the
After, my lord,
delivery.
after proper.
After including LD period,
Yes.
last day of delivery. Okay. 2/7.
These are all, my lord, dispatch clearance certificate. They give the clearance only after, my lord, get the goods, my lord.
What is the provision for dispatch clearance certificate? In the tender or agreement?
Fine, my lord.
Hmm?
Delivery and inspection is there, my lord, page 47.
Page
Page
47.
47. By this, my lord, they dispatch certificate, they direct, my lord, where to deliver the goods.
Now, where is the delivery purchase order?
Yes. 76,
Let us
73
see.
and 76. Fine.
What is LD period?
The, my lord, it is mentioned in the order when it is to
Minute
delivered.
A.
if there is a delay, my lord,
And
then
next, sorry, if so this dispatch clearance is for delivery at the
delivery after
designated district and medical college hospital.
delay medical college hospital, after looking at the, my lord, the test report and other things.
Test report is to be enclosed.
Yes.
Okay.
Now, my lord, these goods were delivered, my lord, as your lordship got it, my lord, in earlier case, my lord, the black waffle. 76. At page 72, my lord, these were delivered, my lord, in approval, that is March, and then thereafter these were delivered. And payments were made, my lord, in July and August. July and August payments were made.
Payments were page
In the same, my lord, here there, page 72, right hand column, my lord,
72.
right hand column.
Also on payment status.
And we have stated
Okay,
the
payments were made.
we have stated in the petition also, my lord.
Payments were made.
Yes, payments were made because we made the supply, my lord, by May and in there are 7, we have said, my lord, that we have made the supply. In so these are completed fund back. Now it appears, my lord, on a suddenly, my lord, they have issued this blacklisting order, my lord.
Is Public Procurement Act, Mr.
My lord, I have quoted it, my lord, there, it is there, my lord, I have given like list of notes also.
Up to date, no? Good amendment.
But I have quoted also, my lord, that.
This is rules. Rules. Yes, Mr. Bora, which you said this is
My lord,
this is issued under Public Procurement.
my lord,
Act.
this is also not, this will not be applicable also, my lord, virtually.
My lord.
Page 17, if you also see, my lord, of my petition, section 46,
Huh?
page 17,
Page?
page 17.
Page 17.
17.
Yes.
First, a bidder shall be debarred from by the state government if he has been convicted for an offence under so and so and so. Then 2, a bidder shall be debarred under subsection 1 shall not be eligible to participate in the procurement process, so and so. And
So
3 for a
you are
period-
reading which section?
My lord,
Which section?
46. section
46. Okay, 1 minute.
section. Now, if you also see section 3. Section 3. If a procuring entity finds that the bidder has breached the code of integrity prescribed in terms of section 11, it may debar the bidder for a period of not exceeding 3 years. My lord, they say that this is the, my lord, they have. Now, if you also see section 11, my lord, section 11 is for a different purpose. My lord.
Hmm?
Section 11, my lord.
Shall be debarred whether state government is being convicted of an offence. Whether shall not be eligible. Well, otherwise, law is settled, it has an inherent right.
My lord.
Law has been settled
Law is
right
settled.
from,
Yes,
right from Erusian.
my lord.
It says bidder has an inherent right, statutory or non-statutory, whatever.
My lord.
Now, section 11, okay?
Section 11, my lord, they are saying, my lord, because section 3 says 11. If you'll also see section 11, no officer or employee of a procuring entity or a person participating in a procurement process. This is regarding procurement process, my lord. Shall act in contravention with the integrity prescribed by the state government. So it is in respect of procurement process, my lord.
What
Filing
is
of the
that?
bid.
What is procurement process?
Filing of the bid, my lord, actually.
Huh?
Filing of the bid.
Cannot be.
Report of integrity shall include.
No, what is procurement process?
If you'll also see, my lord, the code of integrity is provide. Prohibiting any
The
officer.
procurement is defined.
Yes,
Procurement is defined.
my lord.
It will definitely come within the procurement. No doubt about it.
Procurement or public, U, my lord. Means
U,
the
V,
acquisition-
V, W, and X.
W. Procurement process means process of procurement of extending from the issue of invitation to pre-qualify or to register or to bid till award of the procurement contract or cancellation of procurement process as the case may be. So I does not come on that this one.
No. Cannot be.
Because it is till the purchase order is issued, my lord. That is why, my lord, section 11 also says same thing. The entire section 11, my lord, that is in respect of that. Till finalization of bid.
No, that is regarding during the procurement process.
Yes.
Now, here is after the execution of a contract.
Yes, my lord. That does not provide in section 46, my lord. Only thing, my lord, subsection 1 provides that if he is convicted, then, my lord, he can be subsection 1, 46(1). But 46(3) does not apply to me.
Yes, after entering into a contract agreement, where is the provision in the Assam Public Procurement Act?
My lord, this section 11 says, my lord, because, my lord, it is in the process. The process means, my lord, right from the participation in the tender till the supply and the entire process is complete. It's not saying that only for the purpose of participating, my lord. Because 11(2).
But W says till the award of the procurement contract or cancellation of the procurement process,
Yes,
right?
yes, ma'am.
Otherwise, it is clear. Award of the procurement contract
Yes, ma'am.
or cancellation of the procurement process,
Yes.
either contract or cancellation of the entire process. After that procurement contract, thereafter it is governed by the terms and conditions of the contract.
Yes, ma'am.
Different contracts, different procedure, process would govern by different contract.
Yes, my lord.
So maybe you're in accordance with the provisions of the Assam Public Procurement Act 2017
Yes.
in page 91.
Yes.
Maybe that is wrong. Anyway. But in the agreement it is there. Rate contract agreement. In case the supplier fails to
That is-
faithfully perform any of the covenants on his part, forfeit the amount, cancel the contract, or fails, neglects, fulfills,
Recovery of payment made by the.
neglect, put an end to this agreement thereupon every applicable, then you get any time.
My lord, there is a page 58, it says penalty in case of quality.
Hmm?
Penalty in case of quality. Page 58.
Page
Page 58.
58.
That contract. Right.
Penalty in case of quality. So, Bora, this one, page 113. It's a document which has not been provided to him.
Yes, that is true.
Whatever is there,
Yes.
whatever material, it should be provided to him.
And
This is without an opportunity of being heard.
And moreover, my lord, this is on the basis of some complaint, it appears.
Whatever.
After,
But otherwise, they have inherent right.
yes.
The allegation is serious.
Allegation is serious.
It is a procedural left, my lord, but otherwise it is a serious allegation. In a level product of some other company, they have tested their level, my lord, with a different date, my lord. Original expiry date was 2025. They had enhanced it by 2 years, and it was originally of some other company, my lord. they have put their own level on, over it, my lord. It is a very serious.
That will be,
my
that
lord.
will be found, my lord, in
And
one
more
bundle, my lord.
particularly, my lord, in this sector, my lord, health sector, they should not have done it, my lord. In fact, we have filed criminal cases also against him, my lord.
You should have called him. As soon as it is found leveling, you should have called him, at least a representative. See,
Yep.
I know one instance. Apollo Hospital.
Yep.
Right. A person got operated.
In the rules, my lord, that, um, that contact is
But
there.
anyway, this you made a reference to in the Mr. Maybe you may have the right to proceed again, but
Yes, my lord.
investigation report, you make a mention in the impugn order, page 91. That was not furnished to him.
Yes, my lord, I understand, my lord, this probably that liberty may be given so that we can proceed in accordance with.
Okay, I'll go through it. If the possible, day after tomorrow, I'll dictate.
Yes,
Or otherwise, I'll reserve.
yes.
Keeping reserve will takes time. Dictate is better.
With the
If
procedure,
anything, you find out from the rules, Assam procurement rules. Otherwise, we don't think procurement process, it comes within that. Right? Anything in the rules for blacklisting?
No, my lord,
In the rules?
no.
No.
but my lord, for section 11, my lord, it can part says, my lord, because section 11 of the act, my lord, 7(3), my lord.
11.3.
Yes, ma'am. Without prejudice to the provisions of chapter 4 in case of any breach of the code of integrity by a bidder or prospective bidder, by a bidder or prospective bidder, as the case may be, the procuring entity, after giving a reasonable opportunity of being heard, may take appropriate measures, including exclusion of the bidder from the procurement process, calling off of pre-contract negotiation and forfeiture or encashment of this security.
Okay.
Forfeiture of encashment of any other security or bond relating to the procurement. Recovery of payment, because he is claiming that payments have been made. Recovery of payments made by the procuring entity along with interest thereon at bank rate. Cancellation of the relevant contract and recovery of compensation for loss.
I was looking for it. You were not showing it.
Yes, my lord. I was.
You are not looking. You should have shown it for. We are trying to find out.
Yes, my lord. Then, my lord, F, debarment.
I have seen now. I have seen now.
Yeah, debarment of the bidder from participation in future procurement field.
So without prejudice to the provisions of chapter 4.
Procurement, my lord, process, my lord, that rule 24, my lord.
Huh?
Rule 24,
Rule 24.
method of procurement and procedures thereof.
24. Rule 24, Rule 24. 21. 20. Twenty-four.
Case 83.
This
is the procedure, my lord. And that contract comes later on.
Anything on debarment or holiday listing or blacklisting?
No.
Hmm?
The different types of, my lord, procurement processes there. E-tender and other, my lord, competitive bidding, single source procurement, limited bidding. These are there, my lord. Then electronic reverse auction, request for quotation. They are there. Spot purchase. So this is the procurement process, my lord, till the red contract is there.
Repeat orders. Okay. If possible, day after tomorrow, I'll
Yes.
pass the order. Heard,
So
Mr.
the authorities may be given the liberty to act in proceed in accordance with the procedure.
Zian Sawant and Senior Counsel, listed by Mr. A.R. Pal, Learned Counsel for the petitioner, DP Bora, D for Dipank. P. Bora, Learned Standing Counsel, Health and Family Welfare Department for all the respondents. Full stop. Okay, and let notice be issued. Full stop. The Learned Counsel for the parties have submitted that exchange of pleading is complete and all the have submitted that all the respondents are represented and exchange of pleading is complete, comma, the case be taken up for final, the repetition be taken up for final consideration. So accordingly, comma, the notice is made returnable on Wednesday. So notice part is complete. Yes. Next day, Wednesday, will respond. Release the case on. Swens.
Item 44.
Yes.
But I checked, my lord, Mr. B. Gogoi is out of station, my lord. And somebody else was deputed, but he could not come.
Okay.
Only difficulty is, my lord, they will be running out with the work, my lord.
What to do? Mr. R. Dubey, Learned Counsel for the petition is present. Mr. Dubey has submitted that an additional affidavit has been filed to bring out certain additional facts as regards a notice to proceed with the work dated 12/2/2026 issued in favor of the respondent number 5. Close for. The additional affidavit has also reported about the service of notice upon the respondent of 5 by way of Dusty. Close to. We put it next Monday. Next Monday.
Or Wednesday, my lord. Monday I'll be out of station.
Okay. Let the case be placed before the Alwaji Makut for report as regards service of notice upon the respondent number 5. Full stop. Release the case on Wednesday. You on Wednesday?
Yes.
18.
18. 18.
For consideration of interim, because notice on interim pair was already issued on.
Okay. For consideration of interim prayer.
Mine.
The standing council. Yes, public works or elected.
PWD.
PWD. Is found absent today on call. Nobody is there, no?
No.
Yes. Order.
4 orders. Item 45.
Yes, sir. 43.
This is my content matter, my lord.
Yes.
On last occasion, my lord, Mr. Bhumik,
Nobody, I said, nobody is interested after 3 o'clock. Not yet 4:30.
in that case, it's better to take up the matter, orders matter first, my lord. Then people will wait for the motion, my lord.
Good suggestion.
Yes, my lord.
We'll start the motion at 2 o'clock.
Yes, my lord. Then people
Everybody will be there.
Yes, my lord. It's pending since, my lord, 2024. Order is at 2/8/2024.
P. Bhumik, how earlier who used to represent?
Earlier, Mr. Nayak, P. Nayak. But yes.
But on the previous date, we said that Mr. Bhumik
Yes, my lord.
was found in attendance. So asked him to obtain instruction.
Yes, my lord.
But he is not directly.
Yes, he is not directly, he did not file Okalatnama also. Mr. P. Nayak and I
So
think.
we asked him to render assistance.
Yes, my lord.
Oh. S. Bora, yes. Your name is there still.
PTC content.
PC content, we are asked not to API.
Huh?
PC content, we are asked not to API. All the contents.
In that case, my lord,
Free homing is to API in all cases of whether it may AK हुई or free homing cases.
they have not filed any wakalat number till date. Or else, my lord, I can take a fresh steps.
You file withdrawal application, withdrawal letter before the registry. Your names are reflected, right? Mr. D. Shoikia, S. Bora, P. Nayak,
Multiple, I think there are multiple.
R.K. Musahar, you file application for withdrawal, then we can take it record, then thereafter we can proceed for maybe issuance for warrant also. But if counsels are there, they are not withdrawing the Ukalatama from record, how can we?
Well, that can be done, matter. Later.
We have to take some stringent action. You file the application at least before the registry.
Yes, my
That I am specific instruction, I am withdrawing my Ukalatama. All the names appearing, otherwise it is showing you in bad light.
That's first.
It will be in bad light.
Yes.
Next, they will say that my counsels were there. How can adverse order be passed by the court? Ultimately, all rolling around, ultimately blame will be to the court. Okay, Mr. N.J. Khatuni, learned counsel for the petition is present. First, Mr. S. Bora, learned counsel, has submitted that earlier he used to represent the respondent number 1 and 2.
1 and 2, my lord.
1 and 2.
That's the person.
Post up. Subsequently, he has received instruction not to appear and represent the respondent number 1 and 2. Post up. To that effect, he will file an application. Subsequently, he and others who is to represent the respondent number 1 and 2 have received instruction not to appear and represent them. So to that effect, he will be filing an application before the registry within 2 days from today.
Because
2 working
other
days.
advocates also there. I
Huh?
think from the other advocates, one of them is not in Gauhati itself now.
You on behalf of, that will do. Okay. By Friday. By Friday. So, if such is the position, then there would be no learned counsel to represent the respondent number 1 and 2. Post list the case on 30th of June.
My lord, this short date, my lord, we have.
Definitely.
Obligation.
Item 46.
46, 47, 48.
48, I have filed my affidavit, my lord.
Everywhere your name is there.
I have filed my affidavit.
In every case.
All the 3 cases.
All the case. What is the ground? No money.
That they are entitled to the amount. The calculation is made, but the amount it will have to be disbursed from the government or something. We have written a letter that this amount is due not only him, there are other contempt cases. In contempt cases, around 23 crores have still to be debt. The moment the amount is been disbursed, it will be disbursed to all the, including the petitioner, the other persons also will disburse it.
You are Thakuria.
Lordship.
In the other case, you have filed.
Other cases, same standard.
Same stand. This is 47 and 48. In which case 46, 47, 48. In which case you have filed Laukalanama? Affidavit?
Possible take the first case, my lord, all the cases are filed, I think. All the 3.
No, court may pass adverse order also, that is why. Affidavit. Whatever affidavit. In 48. I can look at it.
46, 47, 48.
Okay.
All the 3.
We will now put it together for convenience.
Yes.
heard Mr. A. Thakuria, learned counsel for the petition, and Mr. S. Bora, learned counsel for the respondent. So Mr. Bora has submitted that an affidavit in opposition, affidavit has been filed on behalf of the respondent in item 40.
No, 46, 40, all the three.
All have filed. In all the cases you have filed.
All the cases.
Okay, okay. Okay. List the case on sales. Purega Didi Bata did it.
23rd March, 2303.
Any possibility of having the status report?
I will get the updated, let it be on the after before my lord later, because the March in that amount may affect from my and this was a start.
First, April or first week of June? 6th of April. In view of the stand taken by the respondent in the affidavit, list the case on 6/4/2026 in order to enable Mr. Bora, learned counsel for the respondent, to apprise this court about the status of disbursement. The status of
Disbursement.
disbursement. 6/4.
It's okay.
Highly obliged.
So we'll take all these three. Or we'll take all these three spaces to get amount.
Item number 49. May it please your lordship. This is a review petition that was filed.
The documents you have mentioned that are found mentioned in the judgment.
No, that are mentioned in the judgment, but your lordship.
And
held in
whatever,
paragraph-
right or wrong, some observation will be made. Whether it comes within the scope of review to re-agitate the same matter,
No,
I have already observed, if I am not wrong, then page 25, prior to that, all these documents, 18/7/2013, then 23/7/2013, then 26/7/2013, 9/7/2013 meeting, all these are recorded
what I'm.
in the judgment.
No, I agree with your
And
lordship.
ultimately, I have said, paragraph 25, that this court is not capable of reaching any finding. So, is it not a case of re-agitation of the same issue?
No, if subject to correction, if your lordship kindly peruses paragraph 36, page 46. Summing up, it has emerged from the discussion that the act of demolition of the coke manufacturing unit installed at the subject plot carried out on so-and-so was without following the due procedure and was in violation of the principles of natural justice, as no prior opportunity was afforded to the petitioners prior to 26/7/2013. But the liability cannot be fixed.
Right.
Specifically on any of the respondent authorities or in the district administration and Coal India Limited in the instant writ proceedings, as these respondents have taken stand which are at variance to each other, shifting the liability of demolition on them from them. No direction can be made for making payment of any of the amount as losses suffered by the petitioners for the reasons recorded. It has also emerged that on 26/7, no exercise of eviction of the petitioners on the subject land was carried out. Now, your lordship, this part, the part that starts from the second last line, but the liability cannot be fixed specifically. Now, if your lordship comes to this part and the last line that I was just read out, it has emerged that on 26/7/13, no exercise for eviction of the
Yes,
petitioners.
I said.
Hmm. What I'm
that-
saying,
That eviction from the subject plot was not carried out. But demolition was carried out. There is a difference.
I agree.
And secondly, on demolition, this court has expressed its inability to affix the liability. This court has already held.
No, what I'm saying is this part. Now, if your lordships goes by those two documents, the documents they have relied in, if your lordships can.
Mr. Sore, I have already rendered my view. It is subject to correction by appellate court. I have already rendered my view, paragraph 25. After that, on those documents considered was not considered. Considered, I have indicated to you. Para 21, 22, 23. All three documents, four documents. There was meeting on 9/7/2013, minister. Then there was an order, office order, 23/7/2013. Prior to that, another office order, 18/7/2013. Then 26/7/2013. Right, demolition exercise two coke manufacturing units. Then paragraph 23 again, there stand. I have considered all the 3-4 events and office orders, documents mentioned, and what deployment with men and force I have recorded. Then thereafter, another significant issue is the criminal court judgment, where the persons have been specifically acquitted. And I asked you also, whether did you prefer any appeal? And from that, they were recharged. You might say that departmental proceeding or civil proceeding or criminal proceeding is different.
Exactly.
Standard of liability is different. But by this already, in respect of demolition exercise, I already said that this is not possible for the court. We are into affidavit. We do not decide fact finding on the basis of affidavits. And if affidavits somebody admit, then only we can do that.
No,
Otherwise,
in their affidavits.
simple contract dues,
No, if you're.
even for 100 rupees, we do not decide unless they admit.
No, in their affidavits, it is nobody's case so far as the respondents are concerned.
Mr. Chori, it is re-agitating the same matter.
No, if I have been able to express it in my own way, paragraph 36, the observance that the liability cannot be affixed. Now, in this part, my interpretation, subject to
No,
correction.
that is what your interpretation
No.
and court's interpretation.
No, I agree. Ultimately,
You
it is
have
the court's finding.
interpreted.
It is the court's finding, I agree. But if your lordships considers their affidavits, especially the affidavit of our respondent
Exactly.
number 2,
Good case for appeal.
but then this case was not dismissed.
Which one?
Had my writ petition been dismissed, I could have preferred an appeal. In my
Oh,
case,
any observation made by the single bench is subject to appeal. I don't think it is not.
no, here
amenable
is a
to
case,
appeal.
your lordship, if your lordships agrees, one of my bone of contention was that there was violation of that I was never heard. In this case, your lordship has held that I was heard. I was never heard, and that observation is there. That there is a violation
See,
of.
I say,
this.
Mr. There are two issues. One is demolition of your
Coke manufacturing
coke
plant.
manufacturing unit. And second one is eviction from the subject plot. Right. I already held, please bear with me. I already held that on that day, eviction exercise from the subject plot did not take place. I have clearly held. Am I not? So it is, whether it is a public premise or it is a plot of land belonging to so and so, even an encroacher has a right to notice. I have held. So far as demolition of the manufacturing, coke manufacturing, yes, it took place. Right. Now, a read court on the basis of affidavits, right,
stand taken by the respondents on the basis of affidavits cannot affix the liability to whom it is to be fixed, who had demolished. This is my view. Right. This may be reversed, but on the basis of same documents, we cannot sit again in the guise of appeal. Parameters are clearly laid down in Order 47, Rule 1, read with 114, Section 114 CPC. And that spirit is to be followed in the writ proceeding. Right. So this is, all these documents were part of the affidavit, and I have discussed it without missing anything. And thereafter, I recorded a finding that I cannot fix the liability. This is writ proceeding. Because of the subsequent acquittal, discharge of the Coal India officials and others,
No.
I have expressed my inability. This court is handicapped to fix liability. Now, you are trying to make me to fix liability.
Not for fixing liability, but the very fact is that from their materials available on record reveals that they have not denied the fact.
That is your view of the matter.
No, it is not because in the writ proceeding, our bone of contention was that demolition had taken place and there are certain other attending facts and circumstances under which the demolition had taken place. Now, in the affidavits by the respondents, either by the Coal India authorities or they have never stated, even the police station was deputed, the concerned police administration for deployment of forces on the day on the which demolition was carried out. So
Okay,
in that,
I'll decide to whether to issue notice or not to issue notice. Within the parameters of review jurisdiction. I'll decide the grounds you have taken, because all the documents you have referred to, I have also referred to in my judgments. So I'll decide whether to issue notice or not to issue notice. If issue notice, I'll issue notice.
Your
If
Lordship,
not,
just issue
I'll record
notice.
my reasons. If not, I'll record my reasons. Right. If it is reopening again in the guise of appeal, no.
Your Lordship, whatever Lordship proposes, that I'll have to abide. But my point is that it is nobody's case, so far as the respondents are concerned, that they have never stated that demolition was. Since this observation was made by the my Lordship, in paragraph
Sir,
36.
I thought I conveyed my intention across the board for certain benefit to the petitioner. I never thought that it would be for review of the judgment. I thought that I'd be able to hand over some handle to the petitioner. If he wants to use this handle for the purpose of review, then
No,
maybe
it may not be interpreted in that manner. Your
next
Lordship.
case. Because I conveyed at the time of hearing whether I could leave, because these are disputed questions of fact which cannot be decided. On the present facts, this is my view I had said. Now, if you, in the guise of review again, you want
No,
to
that may not be
reopen
interpreted in
my
that
case.
manner, Your Lordship. What I am saying is that since
Okay, we'll see.
because
see.
because before preparing the review petition, in my humble submission, we have considered the stand taken by the police administration in their affidavit, the district administration.
I
and the-
think I have dealt with every affidavit in opposition. Nothing has been left.
So thereafter, if Your Lordship
If I
sees-
missed,
No, what I'm not on the thing that Your Lordship has missed any of the point that they have raised. But my point is that that observation that was made, that no liability can be fixed to that extent, because they have never said that we are contemplating that if Your Lordship go the language of the affidavit as well
shall
as
I?
the truth.
Let us decide what is review jurisdiction.
First, let us decide what is review jurisdiction. Order 47. এনেকুৱা নহয়, এখন এনেকুৱা যে আছে, ওপৰত তাতে আছে। চাওঁ। It will be within the parameters of 47. Any other matter? আৰু আছে নেকি বাৰু? 50 item না 50 review. 50 আৰু কিবা আছে নেকি? Only 50 is left, no? Good. Petitioner should notice 5 and 6. Okay. A Amit for the petitioners, A Gayon, Standing Council or Central Government Council for the respondent number 1 to 4. Peruse the office note dated 6/3/2026. The Miss Gayon, when do you want to file?
And for getting my
Okay. For whom? 6. What about 5? 5? 5. About 5? You are only for 6. Okay. Miss S. Borthakur or Patra Wuhan. Learned Council has submitted that she has entered appearance on behalf of the respondent of 6 and an okalatnama has also been filed recently. Post of Peruse the office note dated so and so. Ms. Gayon has submitted that the counter affidavit on behalf of the respondent number 1 to 4 has been draft counter affidavit has been sent for vetting, and the same would be filed within
4 weeks.
4 weeks time.
Yeah.
4 weeks time. Para. The case be placed before the Luaji Court for report as regards service of notice on the respondent of 5. It's 4 weeks time to talk about it. For a report as regards service of notice on the respondent number 5. List the case next week or date for service. Huh? No, it is for a report so that we can proceed ex parte against respondent number 5. Right? Thereafter, I'll grant time. Okay. We'll pass order in a review. You were there? Yes, what is your submission?
No document, we can use. One only big mistake. But if there would be 2 views, and honorable court has taken 1 view, and a review has filed, no, honorable court may take another view also. Review is not permissible. Same judgment is.
Okay. Recent judgment.
22/11 Astra 40, full bench judgment, my lord.
Okay, you can have some. 2020. Okay, Mr. Chaudhary, you want to give also?
In that case, I am also placing some judgments.
Some judgment, no, 1 or 2. 1 or 2, otherwise.
Yes. AI 1960.
Law is 1 line.
uh,
Law is 1 line, whatever may be.
AI 1963, Supreme Court 1909.
Which one? Name.
Shivdev Singh.
I rely on that only.
And
No issue.
there are two more.
Shivdev Singh is quite clear.
2022 Supreme Court 734.
Para 3 is clear. Shivdev Singh, para 3.
And 1994
No,
one
no, two,
SCC
two, we
17.
limit it to 2 paragraph.
Yes. May I just hand over the copies?
Today may not be possible.
It's okay.
Day
Lordship
after
may take
tomorrow.
time. I'll hand over.
Obliged.